So the U.S. versus Lollar case is a very straightforward application of Rule 608A. And in this case, the defendant had taken the stand in his own defense. And after the defendant has testified in its rebuttal case, the prosecution calls one of its witnesses back and says, "Would you believe the defendant if he testified under oath?" And the court says, in this case, that that's a perfectly appropriate question. Now, I mean, this seems kind of crazy in some ways because, I mean, it just seems too direct. It seems almost, it's too hard of a punch to allow. The defendant has just finished testifying. They call someone up to the stand, and basically they say to this human being, "Do you believe this guy?" No, no, I would not believe anything he said under oath. He is a liar. I mean, that this just seems too insulting. It seems too much without foundation to permit, but that is precisely what Rule 608 allows. You can bring someone in and establish that the witness knows the witness who previously testified, whether that's the defendant or someone else, and say, in your opinion, is this person a liar? In your opinion, is this person telling the truth under oath? Or in your opinion, would you trust this person under oath to tell the truth? And the witness can say either his reputation for truth-telling is not good, or you can say, in my opinion, he is not a truth-teller. And the very specific example of that case is, would you trust him to tell the truth now under oath? That's one half of a step beyond my opinion of him is that he is not a truth teller, but the court allows that. Do you think the defendant's lying with what he just said under oath? You can ask that question under the Lollar case. Now, there may be some courts who try to rein that back, some trial courts who try to rein that back in. But this is a very direct application of Rule 608A. You can bring that witness in to say that, in my opinion, and I know this guy, in my opinion, he has a bad reputation for the truth. And so even though it seems like it's a statement, it's a very accusatory thing that for which we're not offering foundation. In fact, you cannot offer foundation for this. And it's funny how a person's, yes, that guy's a liar, seems to have a bigger sting than the reputation for good character. We tend to discount when people say a person has good character. We tend to buy it when they say a person has a bad character for at least truth telling, and that is allowed of any witness, or you can say that about any witness, so long as the person who's saying it has some basis for making the claim, which we don't inquire about, other than to say, do you know this person? How long have you known him? And in your opinion, what's his reputation for the truth? Or what's your opinion of his or her truth-telling? 608A allows what just seems like a direct insult without foundation. Now, you can cross-examine that person. Isn't it true you've known this person for years? You've only known of 3 lies or whatever. You can cross-examine on specifics. But the direct testimony doesn't have to be supported with the foundation. And it's kind of hard to prove a negative like this. How do you cross-examine on specific events to show the person is in fact a truth teller? But that's what you're kind of stuck with if the prosecution or if the defense brings in a witness to say that the opposing party's witness is a liar in the witness's opinion.